बैठ जाओ भैया।
हाँ सही है।
इधर बैठो ना।
So we come to the concluding part of this presentation, this series of lectures, and what I have chosen to do in this final class is to give a summary of what we have done in all preceding 12 lectures. So we recall from our first lecture that was on the concept of interpretation as such, and we discussed through a number of references of cases and literature. And it is possible for us to conclude that interpretation is both a product of determined intention of the enacted or agreed law or its makers, or meaning of the enacted or agreed law. So that is what we say in the first case, is that it is a product. For instance, a reference was made to any competent organ and which has given an interpretation. So that interpretation which has been given by an interpretive organ is a product. Interpretation as a product. It is determined in the sense that it has been rendered by the competitive organ, competent organ. It is expressed either as intention of the enacted law or intention of the agreed law, is still intention of its makers. What we call in domestic law as legislative intention, referring both to the intention of the legislation and intention of the legislators as expressed in the enacted form of law. That is one way of looking at interpretation. That it is a product of a competent body which is authorized to give interpretation. It is judicial body in most of the cases in domestic law, and also non-judicial body under international law, that we will see in a while. Second, and that is also more important and more frequent, that is, interpretation is a process of determining the same thing. Intention of the enacted or agreed law or its makers, or meaning of the enacted or agreed law. One more clarification, that the terminology of intention is much more frequent in common law systems. The terminology of intention is far less frequent. It is very rare in the vocabulary of interpretive organs under international law. Rather, they express this in terms of a meaning. So they do not refer to intention. What they say, this is something too subjective. And for instance, even in common laws, typically in the United States, the terminology of a meaning is very popular amongst the exponents of legal realism. Political and legal philosophers who adhere to the philosophy of legal realism, especially of John Chapman Gray and Oliver Wendell Holmes. So Wendell Holmes was very well known for his preference for meaning of the enacted law rather than of intention. What he said is in his very well known article in Harvard Law Review, A Theory of Legal Interpretation, 1899, most of the volume 10. So that is what we did in the very first class, and that was on what is interpretation. Then the second lecture was devoted to forms of enacted or agreed law. We surveyed number of forms of enacted or agreed law, and we concluded that there is no exhaustive form of enacted or agreed law. But it is also true that most prominently there are two forms of written law, that is treaties and legislations. So most of the time what is referred to for interpretation before in domestic courts is legislations, also called as statutes, and on the international plane most of the time it is treaties. But certainly we also discuss international judgments, which were referred to refer for interpretation to the International Court of Justice. So we also did that. But these two forms are most prominent forms of written law which have been the subject of interpretation by competent authors. We said that there is no one single form. Why? Because there are some very less known but equally frequent and important, that is wills. So whereas the statutory requirement of a will is one thing, that is governed by statute. But in terms of structure, in terms of form, there is no one form of a will. So there could be several forms of wills, and sometimes when there is a dispute, and then these wills are subject of interpretation. So recently there was a case, the case is actually going on right now. Currently it is before Bombay High Court, involving the country's top law firm, that is Amals and Mangalas. And these two partners, they have filed cases against each other.
On will?
On will.
This inheritment of
the property,
of one person.
Yeah. Of given in will by their mother. And this case, very interestingly, one of these two firms have two top offices. One is Mumbai based, one is Delhi based. Delhi based, the son who is heading the Delhi based office had hired P. Chidambaram to argue the case before Bombay High Court. So this is exactly the case. And if you see that will is typically the subject matter of interpretation. It is
will available.
I saw on the internet, not the whole text, but whatever was the contentious area. Relevant provision was there. But of course, that is not an authentic text. I would like to have, let us see when the judgment is rendered, and then I will try to find out the original text. But this case is going on. The very funny thing is this case is going on before Delhi Bombay. And this matter became so contentious, the position that they have taken, they are fighting this battle like they are in gone.
There are a lot of things are at stake.
Money. Real brothers.
Yeah, mystery versus Shroff versus Shroff.
Shroff. That's the case.
Cyril Shroff versus Shardul Shroff.
Yes, this is the case. So I think one Justice P. N. Bhagwati's daughter is also married to
Shardul Shroff.
Yes.
I know.
So this case is before. So that is what I said.
Shrill Shroff has engaged very competent lawyer. One is Solicitor General of Advocate General of Maharashtra, Ambata. And one is MC Chawla's son, Iqbal Chawla. Iqbal Chawla's name came for consideration for nomination for ICJ judgeship. So he is rated very high.
MC Chawla himself.
So basically the question is interpretation of the content of will.
Yeah, both are arguing. You see, their position is that under this will, they should get what they claim. And the will is the same, there is no dispute about the will. And of course, this is a matter of interpretation. So this is, and if one could see wills, I'm not saying that these are the disputes which frequently go, but I presume that the number of disputes that we know arising out of wills are far less than the number of disputes which actually go, because every case is not as, you see, high profile as the Shroff case to attract newspapers' attention. So I believe that these, and because wills presumably are made, because every country, every person who owns property, there is no requirement that you must be an LLB. But you are competent to. So people who are not competent lawyers, people who are not well versed in law, but are competent to make wills. But once they make will, this is a subject matter governed by law. So that is what happens. So they may write one thing twice or thrice or half, that this element is given to my son this, and then again that son's reference is there, and some part of the property which has already been given to somebody. So, it's like, just like any private letter where you do not write in a structured way or one thing at a time and using one vocabulary. So if one thing has been mentioned twice, it gives enough scope for both the lawyers if references to two individuals have been made in that context. So that is something which nobody can predict, the number of forms of it. But certainly
Will is the law.
yes. And that may be subject of interpretation like this.
Will is the law to the extent it is binding on everybody,
Yes.
including the court.
Yes.
So lawmaking is not exclusive prerogative of public authorities.
Yes.
Law can also be made by private individuals,
Private individuals.
which is binding on public authorities.
Yes. That was a very famous case, Reed versus Palmer case, where this murderer, the grandfather, the fellow Mr. Elmer, who murdered his grandfather, and he was denied of the property willed to him. And there Justice Gray said that courts are bound by wills. They cannot become will makers. You cannot substitute for Mr. Francis Palmer. He is dead. So the question before is to enforce it. And you should not be bothered about who the person is, in whom the property was willed by. If he had willed a property who today is a murderer, so it's the second question, it's saying that he should get the punishment of murder, and he already got it. So if you deny him the property, you are punishing him twice. And the majority said, well, this is too reprehensive for a legal system to allow a murderer to benefit from his conduct.
Did they bring public policy argument?
They simply said it, this is a principle.
Just. So they did not refer to.
They did not have any basis in written law. That is what said, this is a classic case. This is again morality. This is a perpetual debate. Law and morality debate. Justice Gray was too literalist. He was too textualist. He simply said, please tell us what the law is. The law was very simple. Law was simple, and every will which is in accordance with law, whatever made admitted to probate, must be enforced. That's it. And there was no infirmity about that will. Because will comes into operation as soon as the person is dead. So the person, it is immaterial how death occurs. Whether death occurs naturally or whether death occurs by murder. Whether death occurs by the person who has been willed property. So what they are saying, majority was saying, that he denied him the opportunity of making another will. So Justice Gray was saying, so why do you presume that if he had lived, if he had not been murdered, he would have made another will? And Justice Gray simply said, he had murdered. He got the punishment of murder.
Yeah, that was too positivist approach to the interpretation of law. That would have fallen flat on the ground of self-destructive interpretation of law. What basically you do in that case, you simply convey a message that when a person executes a will in favor of somebody, then that person, the first thing he can do is just to kill that person to get the property in his favor. That's it. Because law does not prevent that, does not consider that as a constraint in the execution of the will in favor of that person. And people do it in short. In fact, a large number of people who are killed, elderly people,
Yes.
are killed for this reason.
For this.
So that the heirs apparent would get the property transferred in their name. This is a very common case. And then when it is considered a crime. Put it this way, when a person kills a person because he or she is likely to get share from in that property, it is not considered as a crime if the person gets property. Son still gets property if he has killed his father. If a person dies without making a will, and if his son kills him, son may be punished for murder, but son will still get property. So Gray argument was based on that logic. Will is one way of transferring property. There are many other ways. Simple inheritance without will. Will is basically truncating the law of inheritance or subjecting law of inheritance to a special regime. So if you exclude this special regime, the normal regime will ensure that a person inherits property even after murdering his source of property that is going to be transferred. So Gray had a point, because in normal course that also happened. And others also had also a point that in that case, first you deny them, the person concerned, the right to execute another will, besides denying right to life. And the third thing is that if you allow will to come into force this way, then will as an institution, as an instrument of law to manage affairs of people will turn out to be a very dangerous proposition. Nobody will execute will because he or she knows that once will is executed, he or she is a sitting target of getting killed by the person in whose favor the will is made. So I build a point in that, and then comes the question of choice. That's what the choice of law is. Choice of law is not between black and white. Choice of law is not between absurdity and reasonableness. Choice of law is between two sets of laws which both may apply to the same case. Only is a forum to decide which one is more appropriate to the given circumstances. The same is the choice here. And majority choose a law which they thought is more reasonable, more fair, more equitable, and balance of equity, balance of fairness, balance of reasonableness, and balance of public policy went in favor of the position that will should not be allowed to take its effect in isolation. So I see a point in both. And that is precisely what the debate is all about.
Yes, that's
both the
the
debate.
enduring, yes.
Yes. That is what the beauty of the debate is. You don't have a debate between black and white. Debate is always where you have gray areas and you have very strong cases on both sides. That's how debate becomes important. Otherwise, who cares for the debate? You don't have a debate when the sun is rising, sun is there or not. You have debate at the sunset whether sun is still giving light or not. So that's what the beauty of the law is. And that you have two competing options, choices, and you get best out of it. That's what the choice is all about. Otherwise, you have only one choice.
You see, sir, if you see the US Constitution itself, prophetically, so it says that nobody may be punished and prosecuted for the same offense more than once. So in effect, if you deprive that person property because he has murdered, so you have actually done the same thing.
Yeah, but one should be realistic enough. If you apply sociological approach to the law, then this canon of law is violated very frequently in reality. In fact, you punish person not more than once. You punish person persistently over the years. Punishment comes in different forms. One form is that a fellow is prosecuted, punished and sent to jail and is spending his time there. another punishment come in the form which law cannot assess. Not sociologists will assess. Punishment is coming to him in the form of deprivation of his responsibility towards his family, upbringing of his children, taking care of his parents, wife, property and whatnot, his reputation and whatnot, as a constant punishment. So sociologists don't treat punishment the way lawyers treat punishment. For lawyers is a person behind the bars for so many years, that is what the punishment is. This is not the definition of punishment for the sociologist. Sociologists will look at the impact of that act on the rest of the things. And in that case, punishment is more comprehensive, in fact much more devastating deprivation of that person's liberty than what gravity could be. So a sociological approach to law will simply reject this canon of law that no person should be punished more than once for the same crime. In reality, a person is punished more than once. A person who has committed theft has been punished, has spent time in jail, comes out and he is branded a chore, and throughout his life he remained a thief in society, which is a punishment which is inflicted on that person, not by a court of law. But court of law does not prevent society from characterizing that person as thief throughout his life. Court does not come to the protection of that person, that you are punished once and now you are no longer a thief. The person is a thief.
Even after serving the sentence. So this is a precise understanding of what society does, and the one you have in law is a precise understanding of what law expects. So law is not only a statement of law, law is also a statement of values that society should follow. Well, for people, that a statement of values is not very important, a statement of law is important. A statement of values is much more profound than a statement of law. Law contains both a statement of law and a statement of values. For lawyers, a statement of law is a statement of law. It doesn't contain a statement of values. For a sociologist, it is both. So it all depends on what approach you adopt. Positivists say, well, principle is cardinal principle of criminal law. A person punished once should not be punished more than once. That's it. That is what Gray was all about. But that's not how sociologists study law. That's not the sociology of law. And sir, there is another thing that comes out from this case, that the majority made a distinction between rules and principles.
Okay.
And the majority was saying that we are not deciding this case on the basis of any rule, any law, written law. That is true. We have no doubt about it. But there are principles which are fundamental, and that fundamental principle is no person may be allowed to benefit
Absolutely.
from his wrongful.
From his wrongful. And it's a principle of equity. It's a principle of equity, which is cardinal principle of law. It's a principle of natural justice. And that is also another aspect of interpretation. You may find a situation where rule and principle may not be in harmony with each other. This is a clear example that you have identified in this case of Palmer case. Principles are generally profound. They are much more value loaded than rules. Rules are much more pragmatic, much more precise, much more technical in nature. They cover much less than what principles cover. So you generally have a conflict between what is lex specialis in the form of rules and lex specialis that you have in the form of principles. In normal course, lex specialis should prevail over lex generalis. Problem arises when lex generalis constitute the basic foundations of law. when lex generalis constitute basic foundation of law, then that theory that special law prevails over general law, that theory does not apply.
And especially when the lex specialist is in conflict with the general law.
Absolutely.
And this is here was the case.
And this is precisely what the case was. So the normal law is that lex specialis will prevail over lex generalis, but the scheme of law is that not the entire body of lex specialis will, as a matter of policy, prevail over the entire body of lex generalis. There is some lex generalis which prevail even over lex specialis. Not only they prevail over lex specialis, lex generalis remain the guiding post for the interpretation of lex specialis. So even the question of conflict would not arise if the interpretation is made in light of lex generalis. Like fundamental principles of the Charter of the United Nations. You conclude any treaty, however strong and powerful a state you might be, that lex specialis will not prevail over general principles, fundamental principles of law as recognized in the Charter of the United Nations. So this assumption or this popular proposition that lex specialists prevail over lex generalis is not the case. It's not always the case. It is a case, but it is not always the case. So in what situation lex specialists prevail over lex generalis? Broadly speaking, when lex specialist does not articulate fundamental principles of law, or the basic foundations, or the basic, you can use basic features or salient features of law, or the core of law. In that case, the proposition or the understanding or the rule that lex specialist will prevail over lex generalis is correct, because lex specialist offers an opportunity to govern a specific situation with the help of more precise law, and that effort that is made by the lawmaker by defining circumstances, by defining the parties concerned, that effort should be utilized. So there is a purpose in giving precedence to lex specialist over lex generalis. But when that is not the intention, and moreover, there is another aspect where lex specialist cannot prevail over lex generalis. How can a treaty concluded between two parties prevail over a treaty concluded by 100 parties, which is of general nature? Lex specialist is generally made by and for by limited number of entities and for a limited number of entities. On the contrary, lex generalis is generally made by more entities and for more entities. So this wider application of general law, and there is not one body of general law. There are so many different bodies of law. There are general principles of law recognized by civilized nations. There are fundamental principles of international law. There are general customary international norms and the peremptory norms of international law. There are erga omnes obligations. All are general. Not all stand on same legal level. For instance, general principles of law recognized by civilized nations are of procedural nature. You can always enter into an agreement with other party to apply different kind of procedure. For instance, in arbitration, both the parties can say that in this particular case, we will not allow more than one hearing to take place, and a matter should be decided within 3 months. And whatever the submissions to be made by the party that must be made within 3 months. It is not considered a violation of principle of due process of law when two parties agree to a particular procedure to settle a dispute. So due process of law, providing equal opportunity to both the parties, All those are general principles of law recognized by civilizations. But when two parties decide to have an expeditious procedure, a summary procedure for settlement of dispute, that agreement is not considered as a violation of general principle of law recognized by civilizations. The reason for that is that those principles, though general in nature, are not considered fundamental or peremptory in nature, that they should prevail over all others in any circumstances. And peremptory norm criteria explain this difference between one kind of general law and another kind of general law. Not entire body of general law would prevail over less specials.
Sorry for late coming. We thought that we had Viva, we thought that we didn't have class. So we had that Viva exam of jurisprudence.
So you want to attend the lecture, you want to go for Viva?
No, we didn't know that there is class, so of course we want.
He has a permanent audience here in the form of mic and camera. Others are welcome.
I had sent you an email. You don't
Anyway,
get- you don't
lecture
get
is
answer.
going on. You sit down if you want to attend.
Because I never was absent in your class.
But it is a regular Friday usual class. So that is continued. So sir, this was our second conclusion. And our third lecture was on the need for interpretation. So perhaps this was the lengthiest lecture in terms of reference material that we thought was appropriate for discussion. And we concluded, which is representative of the almost unanimous view, that interpretation is inherent in the application of enacted or agreed law. Because
let me just present to you a proposition, just to put a rider to this particular statement. Substantially supporting what you have made. You are trying to say this, but at the same time putting rider to the substance itself. Interpretation is inherent in the application of not only enacted or agreed law, but it is also inherent in the application of law that is not written and that is not agreed upon. Both. In fact, there is greater scope for interpretation.
in non-enacted or non-agreed law.
Absolutely.
But the point was that we included in this only the written forms of law. Because the unwritten forms of law, the problem is of finding evidence.
Yeah. Why I would say that law of interpretation has somehow been unnecessarily focused on written law, which is, in my view, an injustice to the law of interpretation.
Sir, I have included that and I will come to it. I have included that in the scheme of things. So some of the lectures we could not be visiting
Okay.
here.
Go
So
ahead.
that is what I have included that. And that is, I have already covered that it is not only the written law, it is also the unwritten. But this is how we started because this is how the general literature starts. And other and non-exhaustive causations of interpretation of written law include its change. There could be a number of reasons for change. Perhaps the most important premise of adjudication, that is justice, and also unadmittedly, but not infrequently, politics. So these are also usually three, and we have usually given a number of examples when we discussed this particular topic, the need for interpretation. So one is generally the case that it is inherent Unless you interpret the law, because law is always formulated in an abstract, in a general way, and whereas the general law, abstract formulated law is applied to concrete sets of facts which are before a tribunal. So tribunal actually interprets the law only in the context of adjudication. You have very rarely, very rarely do you have possibilities of tribunals giving interpretations outside of the context of adjudication. And that is, for instance, to give you an instant example is, where for instance, an authority makes a reference to a tribunal to give an authoritative interpretation. So which is not an adjudication. For instance, an advisory opinion, be it the President of India or be it some General Assembly giving to the International Court of Justice. But those cases are rare and far between. In 99.9% cases, it is only in the context of adjudication. And adjudication involves new sets of facts. And for that, the law has to be interpreted. Because law is the same. Today you have these facts, tomorrow you have. Let us see two accidents. Two accidents involving two scooters, they can't be the same. There must be some difference. So that is what the new facts, and sometimes you have to interpret it. So that is inherent. Law can't be applied without it. But that is not the only causation of interpretation. That is what we have said in our sub-conclusion. That's our main conclusion, and then the second line is our sub-conclusion. Other causations are change, justice, and politics. And we have corroborated this with the number of examples that we had given. Then, sometimes it is often presumed, especially by those who look at this branch of law through the domestic legal system, as though only a judicial organ is always and necessarily competent to interpret. Well, that is predominantly true. That is mostly true. But there is no reason to believe that as a legal proposition, as a matter of legal proposition, this is also the case. It depends on the competence conferred by any institutional setup. For instance, under international law, you have Security Council. Article 39. Where is a threat to peace, breach of peace, an act of aggression? Who interprets it? Security Council. You say if it's bad, it's good. You apply sanctions, you always say it's bad. If you are an aggressor, you always say, well, it's bad. Whatever it is. It is not a judicial body, but it does interpretation. Another example is you have WTO Ministerial Conference. This is not a court. This is not a judicial body, but it interprets. This is also true. And these are not the frequent examples of interpretation. But yes, certainly there are examples of interpretations.
It depends. There is one aspect to this competence of the body to interpret law. When interpretative body happens to be an adjudicatory body, there is hardly any question about the competence of that body to interpret the law. When interpretative body happens to be a designated body, there is hardly any doubt about the competence of that body. Problems arise or situations may arise where more than one competent body interpret the law, and both interpretation originate from those bodies in a natural way. There is no artificial way of imposing or exercising competence to interpret. Because it is possible that in respect of one matter, two bodies may have equal stakes. I will give an example of two situations where this happened. Role in matters of international peace and security. Security Council has primary responsibility, so there is absolutely no doubt that it has competence to interpret the provisions of the Charter which deals with the maintenance of international peace and security. General Assembly can interpret any provision of the Charter because it has a role in respect of all the provisions. So you can't say that General Assembly has no competence to interpret the provisions of the Charter relating to maintenance of international peace and security. That's why the assumed responsibility or devised a role for itself in the United for Peace Resolution. And then matter came before the World Court. Certain expenses case, where interpretation of the Charter, role of these two organs of the United Nations came for an advisory opinion before the World Court. So you have three authoritative bodies exercising their roles. Security Council did not exercise because there was no scope for exercising, because they did not interpret because there was no opportunity to interpret because of the veto. But legally speaking, Security Council was as authoritative or competent body to interpret the provisions of the Charter as General Assembly or even as the World Court. This was one situation where three principal organs of the United Nations had equal competence. In fact, Security Council had more competence because its decisions are binding. World Court's advisory opinions are not binding. And General Assembly interpretations through resolutions are certainly not binding. But each one of them is binding in its own way. Advisory opinions are binding by virtue of the fact that they originate from the most competent body in legal terms. Security Council's interpretations are binding because under the Charter, resolutions of the Security Council are binding. And General Assembly interpretations must be considered binding because that's the most representative body in the whole international system. So there are three different justifications for considering which is more competent to give interpretation. This was one case where you have competing competent bodies to offer interpretation of the provision. Second case is local case. Security Council interpreted its mandate under the Charter, imposed sanctions on Libya.
Even when the matter came before the ICJ.
Yes. And then matter came before the ICJ, and ICJ never said that we can't interpret the provisions of the Charter and we can't interpret the competence of the Security Council because Security Council has exercised its role under the Charter. They still dealt with the issue in spite of the fact that they knew that this is within the competence of the Security Council. What comes out of these two instances is that you can have more than one competent body to interpret same law. This difficulty you do not have at the domestic level, but this difficulty is very common at the international level.
Yes.
How to decide or even how to define interpretative competence, because the moment you give interpretative competence to more than one body, you are bound to have two different interpretations. They cannot be identical. Another example where interpretative competence has been actually articulated in formal terms. In respect of the Palestine question, both Security Council and General Assembly has adopted resolutions. Both Security Council and General Assembly. You will find quite a few resolutions on Palestine adopted by the General Assembly and quite a few resolutions adopted by the Security Council on the question of Palestine. General Assembly more, Security Council less. But both have resolutions on Palestine. and they are different. They are not same. In fact, General Assembly resolutions are much more Palestine friendly than Security Council resolutions. Now, it's a debate between General Assembly versus Security Council. It's a debate between power-centric interpretation of international law and justice or equity-centric interpretation of international law. Those who believe in equity justice, we believe that interpretation coming out from General Assembly should prevail over the narrow construction of law that is offered by the Security Council and question fast into the competence of both. So these kind of situations, which are rare at the domestic level, are very frequent at the international level. Then there is another dimension to competence aspect, where you have situations where new kind of institutions are created, which have more competence than even popularly known competent bodies to interpret the law. World Court is the best known body which has competence to interpret any law. But what about those legal instruments which create a body within themselves, where a body is rooted in those instruments? For instance, UNCLOS, International Tribunal for the Law of the Sea. The interpretation of the Law of the Sea Convention can be given not by one body. It can be given by multiple bodies, because convention itself envisages role for different bodies. A state may go to World Court regarding a dispute relating to the interpretation and application of the Law of the Sea Convention. A state may go to International Tribunal for the Law of the Sea. A state may go to an arbitration tribunal on the same matter.
If we have recently
Bangladesh as a result, and then it has been found that interpretation of the same provision given by one need not to be identical with another. Bangladeshi Classe. The interpretation that they have given to continental shelf and Gray, John and all that,
We've
never heard of.
Never heard of.
Never heard of.
In fact, sir, in this Honduras case, ICJ had said it, that the continental shelf beyond 200 nautical miles must be in conformity with these CLCS, Commission for Legal Limits of Continental Shelf.
Yes.
And in this particular case, Law of the Sea, arbitration under the auspices of the Law of the Sea Tribunal said it that what we are doing is in no way comes in conflict with the jurisdiction of CLCS.
Yes. There are two different bodies with entirely different role, and one has very profound role under the Law of the Sea Convention, but has particularly little work in reality. They have not decided. They have hardly decided any continental shelf
matter. And second point is this: you see, this tribunal, this commission is seized with approximately 54 to 55 cases. And one matter, you see, it has taken 1 decade to discuss one matter.
Yes.
So if you consider that period with 54 submissions to it, you multiply 54 into 10, that means 5 centuries and a half.
Absolutely. And one should not debunk this commission because it has dealt with one matter in 1 decade. The reason for that is that submissions made by the states are so large, thousands of pages, lakhs of pages. You can't even go through the documentation to decide about the claim of one coastal state. Now, the point that I am trying to bring to this discourse here is that this gives impression, which you don't want to give, I know. As as if the issue of interpretative competence is not a very controversial issue. So in matters of interpretation, not only interpretation is a controversial matter, it could be a controversial matter. Even the question of interpretative competence could be a controversial matter,
Yes,
as it is.
yes, sir. That the second sub conclusion is clearly incorporated that we say that there is no international law presumption or requirement of the interpretive competence of only a judicial body. So we clearly incorporate that is quite controversial.
Yeah.
We can't presume it that only a judicial body. Let us see the example that we gave of Charter of General Assembly and International Court of Justice. So what we are saying is this: we can't presume that under international law, interpretation is the sole domain of International Court of Justice.
Absolutely.
For instance, most probably, or any other judicial body, for instance, in the law of the sea tribunal, the law of the sea tribunal itself, because it is tribunal means a judicial.
Yeah, not only that, one more thing that one can underline from what I have said is that you may find different kinds of bodies involved by their indispensable role in the same field as you mentioned about the Continental Commission. That is the one major body created under the law of the sea convention. In fact, all claims relating to continental shelf beyond 200 nautical miles must be submitted to that commission as a matter of obligation.
Yes, and both India and Bangladesh have submitted.
Yes, and no matter can be considered final without that commission's deciding that matter. But here you are deciding a matter before commission has decided the matter.
That is the
Deciding
critical
the
thing.
matter.
And on this, ICJ has very categorical statement.
So the reality is that this question of competence is not just confined to that even non-judicial body have competence. This is much more complicated. Question is, what's the purpose of interpretation? The purpose of interpretation is to define law to settle a matter beyond controversy. That's what interpretation meant. Why do you want to interpret the law? We want to know what the law is, how it is going to decide our relationship. If the purpose is not served, then the law of interpretation purpose is not served. And that purpose is not served not because of conflicting interpretations or uncertainty about interpretation, but because of the uncertainties associated with a number of processes and institutions that are involved in the realm of interpretation. I will give an example of human rights, for instance. Interpretation of any right. What's the purpose? Again, same purpose. We define right so that it is available to the persons so that they can enjoy it and then they can develop themselves with the help of the exercise of that right. But when you have innumerable interpreters of that right, the purpose is not served. Purpose is not served because there is doubt, there is uncertainty, there is a conflict about the scope of interpretation. And this is precisely what the case is, what you have with the right to equality at the domestic level. When you have conflicting judgments of the same court, as you have in the case of Supreme Court, if not conflicting, as of today we do not know what the settled law is on interpretation of right to equality, on liberation, for instance. There is no settled law. It is quite possible that next judgment, when it is going to be pronounced by the Supreme Court, would be different.
They have a very good excuse to do it. And their excuse. A tribunal's mandate is to settle disputes.
Yes. Not to decide the law.
And not to make law.
Not to make the law.
And we have interpreted it only as a means to the end of resolving the dispute rather than an end of clarifying the law.
Yeah. So now here I will bring another aspect to it. Very good point you have made. And that aspect to it is when the role of interpretation is assumed by the lawmaker itself. When courts are not in a position to come out with an authoritative interpretation, the best thing is done that matter is referred to the legislature to make it.
But sir, there is a problem even in what the court said. Why? Even when you say that you have only settled a question, settled a dispute, and only for settling that dispute that was the end for you, as a means you interpreted the law, but then can you say that the decided cases will not form what is precedent under the law and will not have consequences for the future disputes that will come before you? So even if you did not intend as an end in itself, even as a means to an end, once you have given an interpretation, that interpretation will operate
Until new law is made.
through the doctrine of precedent.
Yeah.
If you have one,
Well,
and
they
most
may-
of the tribunal have, even if not in the formal sense.
Well, they make law, and only time when they refuse in their limited role, that their role is not to make the law but to decide a dispute. They take this refuse at a time when they can't defend what they have decided.
Yes.
So the best thing is to say, well, my role is limited. The fact is the role is not limited, nor they intend the role to be limited, nor does Constitution allow them the role to be limited. Because authority to make law necessarily follows the law made by court to be considered as law of the land.
Yeah, it is true, sir. The judges, in effect, make law, but it is very rare that they say that they do.
Yeah, they say it when they want to be pompous or when they want to claim some credit. Well, they say they are making law when it comes to interpretation of right to liberty and all that. That credit they want to claim.
Yes.
But
But they know that it is going to be claimed public.
yeah, they don't say that.
Acceptable.
Yeah, they will never say that this interpretation is not ours, this is interpretation of somebody else. They say, well, this is our interpretation of liberty and protection of human rights and environmental protection and all that. So they will claim their right and they will claim their authorship of that law. So it depends on which law they want to claim authorship.
So that is why, sir, I can totally agree with Professor Dorkin when he says that a judicial decision is a political decision. That's absolutely true. It is not always the case that you have only one answer. And including that, there is always one interpretation. Most of the time you have more than one interpretation possible. You accept it. Why? Because it comes from in the hierarchy or in different tribunals. The most, for instance, in the 200 nautical miles case. Now, since you have both the countries had admitted, conferred competence on this arbitration panel, and it has given judgment, you have to abide by this. And you do not know what CLCS would say, if at all it is going to say anything. And it may not even make any recommendation because they know it. First of all, you do not know when it is going to happen. But theoretically, this is certainly going to have some effect, or you have preempted the role of CLCS in some sense. Then, you see, having done that, those preliminary topics, then we came down, the importance of text in interpretation. So we had three broad conclusions from our lecture that we had. The first is that the terms of the interpretive text are required to be first determinant of its meaning or intention. This is true. I mean, if we see the law of the law of treaties, articles 31 and 2, Vienna Convention, and generally the domestic law, this is almost unanimous proposition, at least in theory, that the text, the terms are most important for determining meaning or intention. Second, that is also comes out is that these terms have to be given the simplest, the ordinary, and or grammatical meaning. The terminology of grammatical is not used in the Vienna Convention. That is more popular in domestic law. Ordinary word is used in Vienna Convention. Simplest is also used in some other context, some literature. So whatever, I mean, these three words would capture the essence. Then what kind of meaning are you required to give to the terms? And these are in terms of Vienna Convention, ordinary, grammatical, or simplest. Then it is also our conclusion that terms of the interpretive text have not always been the final determinant of its meaning or intention. This is true because terms are not always dispositive of the meaning. Sometimes the terms could be insufficient, could be absurd, unreasonable, and that we would see in the different lectures that we had on the same subject. Then we had, the importance of context. We also discussed this. This is a subject matter which has been very clearly given the space in the scheme of Article 31 of the Vienna Convention, very clearly, very elaborately. And we have three broad conclusions. The first is a text is required to be interpreted in its context. So one way in which you make text to be capable of giving meaning is that you can't see the text from outside the context. So even if there is some intrinsic limitation or the ability of the text to give meaning, this is compromised, this is compensated by the context in which text is required to be given meaning. The second broad conclusion is that the context of an interpretive text may extend to various forms of text, both within and outside of the interpretive text. That clearly comes out literally from the scheme of things of the Article 31 of Vienna Convention. Then, determination of the context of an interpretive text is not always and necessarily inseparable from an interpretive choice made by the interpreter. Because since there are multiple, context, sources of context given, permissibly given by Vienna Convention, which may be referred to, then sometimes it does involve an interpretive choice that an interpreter may make. You have more than one treaty which you may use as context. You use 3 treaties, you do not use 4th treaty, you find that 4th treaty to be less important, or even when you use 3 treaties, you give variable degree of reliance on different elements of context, even in one or non-controversial source of context. So this is one area which is, once you go out of the text, then you have a very broad, you might recall very clearly, because relevant rule of international law is a context. So any rule, relevant rule of international law, it's a very broad thing to say, very broad. It's very difficult to give any finite or any immutable list of what could be the relevant rule of international law. One way what you can say is that the arguments presented by parties. So one party has presented 2 rules which it considers to be relevant, other party has presented 3 rules considered to be relevant, and tribunal may come out with 6th rule, which is either it considered to be solely relevant or is relevant in addition to what the 5 relevant rules presented by 2 different parties, or may finally say that, well, 6th rule that we say is relevant, one rule one party says is relevant, and 2 rules the other party says is relevant. Only 3 rules are relevant. So, well, that is certainly the role of the third party as a court. Then we discussed the object and purpose. And in this context, we discussed certain expenses case, which Sir was referring to a while ago. And this is again, on the basis of the literature, cases, and the text of the Vienna Convention, again, it is possible to make some conclusions, broad conclusions. First is this, that no legal text may be presumed to be without object and or purpose. It is not always, because lawmaking is not a mechanical exercise or a given exercise. You may find certain common features in treaties But it is not that there is one form of a treaty which is prescribed by international law. Then a treaty must fulfill these 10 requirements. Article 1 should say this, Article 2 should say this. We have some common elements. Or for instance, the legislation. There is no one form of legislation. Yes, some points are common. You have a definition clause, you have a preamble, you have a statement of objects and reasons, piloting the bill. But as you very well know, that statement of objects and reasons is not part of the enacted law. So then comes the discussion of domestic court judges, and they separate what is part of the statute. They consider these to be internal means. They must first be resorted to and be considered as incapable of deciphering the intention or giving the meaning to the terms, and then only do they allow any reference to external sources which includes the statement of objects and reasons. But whatever be the case, whether it is stated expressly or whether it is not stated expressly, but as a matter of jurisprudence, it is not possible to presume the text to be without object and purpose. We refer to in this context that famous path-breaking article by Long and Fuller, Morality of Law, giving examples of two passengers on a railway station. One is fast asleep at 8 o'clock, a passenger having a valid ticket because his train was late. Another example, a gentleman who was not a passenger but had a blanket and a pillow was fast asleep at 12 o'clock because he said that, he could not. He was found to be awake, and the adage, the prohibition on the railway station was that anybody sleeping on a railway platform is a punishable offence. So he said this, then how to decide who is sleeping? And in order to decide who is sleeping, the judge must know the object and purpose of the prohibition. If you do not know the object and purpose of the prohibition, you know what are you going to do? You are going to punish the person who is sleeping. And you know who is that person? A passenger. And you are going to set free the person who is not sleeping. But you know who is that person? Not a passenger. So who is more guilty to be on a railway platform? A passenger sitting, sleeping, or a non-passenger not sleeping? And in order to take this position, you must know the purpose of the law. Without knowing the purpose of the law, you won't be able to decide. And on this, you see, that is why Fuller is saying, even in some cases, we seem to be able to apply the law without asking what is its purpose. It is not as though a law has had no purpose. Law had some purpose. Whether you know it or whether you don't know it. Whether means of knowing are expressed or means of knowing are obscure. Second is, a statutory text may not be expressly required to be interpreted in the light of its object and of purpose. You see, with some study of domestic law, it is possible for me to say this. Because if you see, Vienna Convention does not say this. Vienna Convention, and that is the third conclusion. The second conclusion is typically focused on domestic law. Because in most cases there is no written law of interpretation. But as far as Vienna Convention is concerned, that is very clear. And that clearly says a treaty text is expressly required to be interpreted in the light of its object and purpose. Vienna Convention Article 31 is very clear. You just cannot read a treaty, interpret a treaty in disregard of its object and purpose. That is a non-derogable rule, mandatory rule of Vienna Convention. Then you see, Vienna Convention allows us, and also in some cases, domestic law allows us, because we believe that text is not always capable of giving meaning. No language is always expressive, always determining. And there comes the possibility of special meaning. We discussed, number of, cases, treaties, when we had a lecture on special meaning. Some broad conclusions are possible. First is that the special meaning is an exception to the ordinary meaning. When ordinary meaning is not capable of doing things, then you resort to special meaning. Second is, the requirement of giving a special meaning is part of the Vienna Convention general rule of treaty interpretation. That is very important to say, that this is part of the Vienna Convention general rule. This is not a separate rule. This is part of that rule. In other words, there is only one rule of interpretation in the Vienna Convention, because that is very clear, and if you see drafting debates, it was intended, some arguments were made of making more rules. They said no, we would make only one rule, no matter how many paragraphs, structure and provisions in sub-paragraphs we would make, but we will not make any other rule. That was the predominant view, and that was ultimately adopted. Third is, the necessity of giving a special meaning underscores the possibility of the ordinary meaning's failure to effectuate the legislative or party's intent. This is true, and it is implicit in the scheme of things of Vienna Convention. Otherwise, they had not, made reference to a special meaning if they thought that this general rule would be capable of determining meaning in all cases. Then, after the general rule, you have, in the scheme of Vienna Convention, supplementary means of interpretation. This is Article 32, and which is captured as supplementary means. It is not any other rule. Rule is over, and that is in Article 30. The inherent premise is that the general rule of treaty interpretation is not always or necessarily sufficient to confirm or determine the meaning of an interpretive text. You see, even though the Article 32 is captured as supplementary means, but if you see the content, the word supplementary actually flows logically only from its permissibility of confirming. But when it is also resorted to for determining, the means no longer remains supplementary. Why? Try and understand. Supplementary means, according to Vienna Convention, may be resorted to in two possibilities. One, that general rule has already given you meaning, and you just wanted to confirm it. You may use supplementary means. Second possibility is, general rule has not been able to give you a meaning, which the tribunal may adopt. For instance, the meaning it gives is absurd. The meaning that it gives is unreasonable. The meaning that it gives is obscure. Then the question is to actually determine meaning. And when you use supplementary means to determine meaning, then it is no longer supplementary. Then it becomes a primary means. Because on the basis of primary, in other words, general rule, the meaning given is absent. So in that sense, you can see, well, that is simply an observation of, in terms of the word that was used. I'm sure they must have debated this particular, aspect, and I have not come across in literature why they have used the word supplementary, and whether it also goes equally to both these permissibilities of confirming and determining meaning. But another thing that you notice is then these supplementary means are not finite. Two supplementary means are stated by name. One is circumstances of the conclusion of a treaty, and the second is preparatory work. But the choice of the word preceding these, including, clearly shows that these supplementary means are not finite. Then again you have an interpretive choice, discretion. And this must be so. Please try and understand, half of the purpose, if we use that mathematical language, half of the purpose of supplementary means result is when the general rule fails. So how can you restrict the tribunal by finite supplementary means? Because in a situation where a general rule has failed, then the tribunal needs as many sources of meaning as possible. Because the purpose here is not to confirm, but purpose here is to determine meaning. And that is absolutely logical. And yes, at the same time, you have given two expressly stated means. The conclusion is that before resorting to any third source, which is unwritten, but certainly is permissible, these two supplementary means must be exhausted. At least that is a simple logical understanding. Because, yeah, you say that there is no preparatory record of a treaty, fine. There doesn't exist record, obviously, you are not going to invent that. But if there does exist, then you have to resort to that particular preparatory record. If no record is available, then you certainly have to find out the conclusions, the circumstances of the conclusion of the treaty. And from there you have to find out the meaning. We discussed cases on all these. Preparatory work, we used Pepper versus Hart case. That's a classic case. In the English speaking world, that is a classic till there. Circumstances of conclusion, we used EC Computers case. So you could know it. There was another case which was used, you see, in that gambling, US gambling case, WT285 case. Circumstances. So this is how you see. So you can see that supplementary means are also very important. Then further on, now we come to the unwritten law of interpretation. What we have found on this. The first thing that you find is, as far as municipal courts are concerned, they have categorized statute legislations as penal and remedial. Most often they do it. If there is a possibility of doing this, they would almost invariably do it. And after doing this, then they will either give strict interpretation or liberal interpretation. If they consider a statute to be penal statute, for instance, Indian Penal Code or Afghan Penal Code, or any tax statute is constructively called a penal statute, then they will give strict interpretation. If they consider a statute to be a remedial statute, then they will give liberal interpretation. This is typical of municipal courts. Absolutely there is no written law. But this, notwithstanding the fact that this is unwritten law, you find it most frequent in domestic legal systems. Certainly of common law origin. Coming to international tribunals, as far as unwritten law is concerned, international bodies have given restrictive and effective interpretation to treaties without characterizing the nature of treaties as penal or remedial. They do not make this particular, the domestic law terminology, I have not come across. That international tribunals have made, used this, adopted this common law terminology of characterizing treaties as penal or remedial, and then on their understanding of the nature of the treaties, and then conditioning their interpretation. They don't do it in this manner. Yet, it is true, then they have given restrictive and effective interpretation. Effective interpretation they have legitimized is on the basis of the Vienna Convention. And their reasoning is this, that each and every word of a treaty must be given effective. And to that extent there is a municipal law. But municipal law, they do it under a different maxim called, there is a presumption against surplusage. So you should not use any word of a statute as being surplus and ignore it. But it is true that they do not use penal and remedial. Restrictive interpretation, International Court of Justice has given it. You have several cases we discussed. For instance, one is that then they say that treaties are basically restrictions on sovereign states. And if more than one interpretation is possible, one would restrict sovereignty of a state more, another would restrict sovereignty of state less, then the interpretation that restricts less shall be adopted. Example, for instance, easy hormones case. Example, for instance, then you have permanent court assess Wimbledon case. So you have this. For instance, another example, you have US Trade Act case. That is called principle of in dubio mischius. That interpretation less restrictive of a sovereignty should be adopted in case of the possibility of more than one reasonable interpretation. It is not that in an absolute sense that you should interpret a treaty in such a manner that it should, you see, give less and less consequences on state sovereignty. No, that's not the case. The situation arises only when there is a possibility of two reasonable interpretations. The consequences of one is to have more consequences, more restrictions on sovereignty. The consequences of one will be having less. But both are reasonable. Then only. So if there is a reasonable choice, this is not an intention, this is not an attempt ex ante, ab initio by a tribunal, then it would mean that you don't want to effectuate the obligations of a sovereign state. So interpretation is not a means and should not be to subvert, to escape from giving effect to one state's obligations in the name of restrictions of sovereignty. Then another unwritten law, you see, is very well known. Sir has already referred to this in his earlier discussion. Equity. At least some conclusions are in order. First is that equity has also been an interpretive consideration. We have done it. We have seen a number of cases, both from domestic legal systems and from international legal system on this. As far as International Court of Justice is concerned, at least in one very well-known, perhaps the best-known case from ICJ, ICJ has made a distinction between equity, infralation, and other forms of equity in the interpretation and application of law. That is frontier dispute case, Burkina Faso Mali case. As far as Vienna Convention is concerned, Vienna Convention does not state equity as an interpretive consideration. You don't find it written in the Vienna Convention. There are other considerations. Apart from equity, you have other considerations. For instance, usage. You find it in the municipal law most often. The principle of harmony, and from there, students of municipal law interpretation, they are very well aware of harmonious interpretation. You have in the context of Indian Constitution, Articles 25 and 26 of the Constitution, given harmonious interpretation. The principle of efficiency. We saw very recently a case from the US Supreme Court concerning environment. Yes, efficiency, reason, and none of these have been referred to by the Vienna Convention, at least expressly. I am not saying one or the other may not be implicitly or may not be justified under the Vienna Convention, but as far as the letter of the law is concerned, none of these have been stated expressly in the Vienna Convention law of interpretation. And therefore, our final conclusion is that written law of interpretation is not the only or a complete law of interpretation. That is what Rousseau was saying, and we have again, after seeing unwritten sources of the law of interpretation, this is certainly what we can say. So if we study only unwritten law, then we necessarily study only partly the law of interpretation, which we have not done that. We have included unwritten law also, and whenever it was possible, so we included that in our discussion. That is all what we have done in this lecture series, and we will take up any point for discussion. Thank you.
Want to ask anything?
Sir, I have a question.
Yes, please.
Maybe that will be a repeated question, but I
No,
get
please.
it.
Yes.
For example, the customary law is the base law for the, if it is a treaty law, if it is for all international law. If there is
Yes. Please say it again. Customary law.
customary law is in fact the basis for the international law. If it is treaty law, it's a basic law for the international law. If there is something vague in the customary law and there are the parties that they don't accept, for example, they interpret it by themselves, the states. So, is it are we able to interpret the customary law, or if we are, which body is able to interpret the customary law, international customary law?
You see, it is true that one of the sources of international law is customary law. And the most important difficulty that is presented to an international court applying international custom is to find the proof of custom. As you know, that one element of custom is not too difficult to be admitted as true. But the other element, the psychological element, is not as simple. And immediately I will refer you to a case that we discussed in the class, that is right of passage case. India, Portugal case, Goa case. So International Court of Justice, you see, has admitted it. And this is true also. Proof of custom. The problem is not whether it is a source that is written. That's not a problem. So in other words, it is not a theoretical problem. It is a practical problem. It is not a substantive law problem. It is a problem of evidence in law of evidence. So that is what I will say.
Sir,
Yes, please.
sir, if as you were mentioning about the purpose and the object, if a particular treaty or if a particular law statute is having purpose and objective in its in the statute itself or in the treaty itself, like we have TRIPS agreement, say Article 6 and 7 mentions about the objective and the purpose of the TRIPS agreement. So what does this signify? Does it signify that the object and the purpose is, the status is heightened by that? Like the object is to promote public health, to promote the welfare of the people. It is mentioned in the treaty itself, apart from the preamble of the TRIPS agreement. So what does this signify?
Yes. You see, We discussed it in lecture 6, object and purpose, and we also referred to Doha Ministerial Declaration of 2001, and expressly Doha Ministerial Declaration expressly stated that henceforward, after adoption of this Doha Declaration, TRIPS agreement shall be interpreted more in light of its object and purpose, which are stated in Articles 7 and 8 of the TRIPS agreement. So in other words, TRIPS agreement very clearly, not only in the preamble, so the objects and purpose before adoption of the Vienna of the Doha Declaration, you had to only refer to, in terms of the general law of interpretation in the preamble. But after adoption of the Doha Declaration, it is very clearly, there are two effects. In other words, let me say more precisely. There are two implications of Doha Declaration. One is, that is less significant is, but more clarifying, is that for objects and reasons, you don't have to locate those objects and reasons in the preamble of the TRIPS agreement, but you have to be squarely found in the Article 7 and 8. Second and more important consequence is, in case of any conflict between the text and objects and reasons, purpose, objects and reasons would prevail, purpose would prevail. Because if you see the other elements in Doha, for instance, let me corroborate what I am saying is this. Doha agreement said it is for every state to determine whether a state of emergency exists or not. It is not for international tribunal to say that there is no malaria, and if malaria is not, whether malaria in a sovereign country, whether tomorrow malaria, for instance, in Afghanistan is of the magnitude of a national emergency or not, this WTO will not determine. Afghanistan will determine. That is the impact of this. So objects and importance of objects and reason, you see, you can find it most from the Doha Declaration in the context of TRIPS. Read Doha Declaration. We have it in the literature. All literature was being forwarded to students on every Monday. So see a mail of your group ID of any Monday. You will find that you have all these things. And we discussed this in the class. Thank you.